The patent system is a legal framework designed to encourage innovation and to protect inventors' rights. In essence, it grants inventors exclusive rights to their inventions for a specified period, such as 20 years in the United States. To obtain a patent, inventors must disclose the details of their invention in a document that eventually becomes public. The disclosure, while protecting the inventor's rights, also serves the broader purpose of sharing knowledge to stimulate further innovation. Patents can cover various inventions, from products and processes to designs and plant varieties, fostering a balance between private interest and the public good. So, what can be patented? The criteria includes that the invention has to be new and useful and non-obvious. What cannot be patented are things such as an abstract idea, like a pure math formula, a natural phenomena, like, let's say, if you found some naturally existing plant or ingredients that cure a particular health problem, and laws of nature. So those items cannot be patented because they're too broad and they would block people from using things that should be open to the public to use. So, in addition to patents, you have other legal rights such as copyrights, trademarks, and trade secrets. You can possibly weave out these rights into an digitating set of rights that enhance the strength of your portfolio. So, for example, you can have a patent on how your hardware works. You can also have a design patent on the look and the feel of the products. You can also have a trademark protection on the branding of the same products. And then, of course, you can also have some secrets that you keep, let's say, the customer names of the people that you sell your product to. So those are the examples of overlapping intellectual property rights that you can use in combination to enhance the strength of your product or your new invention. Next, we will discuss the process of obtaining a patent. So, as an overview, the process begins with the idea, the conception of the idea by the inventors, through filing for the patent protection, and then you go through examination, and then eventually the patent is granted. So what do we need for filing the patent application? After you've ideated the concept, then you need to generate documentations about how the invention works. So the documentation can be a number of forms, such as a Word document or a series of drawings, and the combination of which provide a very detailed description of how the invention operates. After we have that, then we can discuss what type of patent applications to file. You can have provisional patent application, you can have non-provisionals, or you can directly file international applications. So a provisional is a temporary application that lasts within a year that must be converted to a non-provisional. The non-provisional application is the one that's actually examined, and that's when you will get some pushback from examiners as to your novelty or your obviousness. The PCT application is for companies that are well-funded, that is interested in seeking international coverage. And the PCT application can be done either upfront or can be done within 12 months of the first application file. And if you do that within the 12-month basis, you can claim the priority date, stretching back to that 1 year. And so PCT is a useful mechanism to defer some of the international expenses because it delays the international filing date up to 30 months from the first filing date. So you can wait to file internationally up to 30 months and still can get the priority date of your first file application. If you have questions, just text me on that. So once you file a non-provisional patent application, it goes into a queue where other applications have gone into, and eventually you'll exit the queue for examination. That transit time is approximately 18 months to about 2 years. And the examiners will pick up your case, and generally what they'll do is they're going to do a patent search, and they're going to try to push back on you if they find relevant prior art that indicates either the identical invention has been done already, or if they can point to 2 or 3 other patents in combination make up your invention, and they'll say that that invention is obvious in light of these 2 or 3 prior patents. So then you need to argue with the examiner as to why the combination of references may not be correct. And if you're successful, the examiner will send you a notice of allowance, and then upon paying the filing fee, it becomes a patent. So once you have a patent, then you have exclusivity for that concept for the life of the patent, which is around, in the US, 20 years from the filing date. Every 4 years, there is a post-grant process where you have to pay a maintenance fee, and if you don't pay the maintenance fee, then the patent lapses. So in general, because this is a complicated process, we recommend that you use the services of a lawyer, or if you want to save money, use software that guides you through the process of writing the application so that you can write a document as completely as possible on your own writing time. And then you can take that document to a professional, such as a lawyer, and seek professional assistance in filing it. We think that that approach is the best way to save money because you know the domain of your technology and you can utilize a software that guides you into this process. And once you have all the documentation in place, the lawyer can use her expertise to refine the claims and to improve the quality of the application to maximize its chances of success. So we recommend that you, the first time you've done it, then use some sort of a software to document your application. And then you take that to a professional and request a discount. And this process will save you money, save you time, and improve the overall quality because you are now collaborating with the lawyer to improve the quality of your application. So now let's delve into the different types of patents. So we have what is called utility patents, and those are for new and useful processes and machines, article of manufacture, or composition of matter. So that's probably the bulk of the patent application that's filed. There is another significant number of patent filing for design patents. And so what are they? They are for original and ornamental designs for an article of manufacture. So an example of a famous design patent is the Coke bottle. The bottle itself cannot be patented as a utility because numerous bottle designs have been done. However, the rich series along the length of the bottle, those are unique, and those identify immediately that this product comes from Coke. So you can get a design patent for that. You can also get a trademark for the shape of the Coke bottle. So that's something to think about. In addition to utility and design patents, we have what is called plant patents, and as the name implies, those are for plant varieties. We see very few applications for plant patents, but they do exist. And so if you have come up with a new plant by grafting varieties together, then that's the domain for you. Next, we will talk about patent search. In general, we recommend that you do a patent search before you start the process of patenting because it's an expensive process. So it makes sense for you to at least do a sanity search to verify that your invention is novel. So part of the difficulty in doing the patent search is how do you search for novel aspects? Initially, you're going to have to come up with an angle on, let's say, what are the minimum features of your invention that you think to be novel. And so what you would do is then go to a search engine, such as the engines available at the US Patent Trademark Office or at the European patent offices. You can also use Google Patent Search, although there are some people who fear that providing that input into a public search engine means exposing the idea to Google, for example. So in general, you can use, there's a number of search engines that you can use for free. So that's one option. The other option is, if you want, is you can always hire a firm to do a search for you. So in a professional search report, they will normally pinpoint. Let's say if you claim novelty, the novelty is they include A, B, C, and D. The search will then pinpoint, where in the references would they show A and B and C and D, and so they may combine 2 or 3 references to show all of the novel elements of your inventions, or it may, and that's called obviousness. The invention is obvious, or they can show everything into one single reference, and that's the novelty. You lack novelty if everything exists in one reference. So in general, we recommend that you, if you're writing a provisional application, just do a sanity search, and then you can use that information to train, to write your application and focus on what is the novelty and how it differentiates from the prior art. And in cases where it's a make or break of the company, and when you think that the patent is so important, then it makes sense to utilize a professional search firm who can search international documents. They can search non-patent document as well. And so that's the way we recommend it is for most inventions, you just do a sanity check on your own. For important applications, you should consider use a professional search firm. Next, let's talk about the 2 main rejection bases at the patent office. The first is novelty, and the second is obviousness. Novelty refers to the originality or newness of an invention. To meet the novelty requirement for a patent, the invention must be different from anything known or used before the filing date of the patent application. So this is why it's important that your invention should not be publicly disclosed or part of the prior art. So how could you do this? It is possible that, let's say, you talk to an investor, and then they in turn then talk to other companies who are in the same space, and then that idea is disclosed. So that's one reason why you should file a patent before you talk to anybody. Next, let's talk about obviousness. Obviousness, different from novelty, relates to whether or not an invention is a logical or a straightforward development based on existing knowledge or technology. If an invention would have been obvious to a person skilled in the relevant field at the time of the invention, it may lack the inventive step required for patentability. Thus, the key in arguing against obviousness is whether or not it makes sense to combine the different references together. So in a rejection from the patent office, they typically combine 2 or 3 prior art references. That could be patents or it could be publication. And they'll say that these references come from exactly your field. So therefore, somebody skilled in the art would be motivated to combine these references to come up with your invention. So obviously, if you take this approach to infinity, all inventions are obvious because anything that you do, pieces of it could have been done by the prior art. So the way you push back against the obviousness rejection is to argue that when you combine these references, somehow they wouldn't work or they're inoperable, or that the references lack a specific point. So that's how, in my work, we push back against the obviousness rejection. The novelty rejection is fairly easy to overcome because it requires an identity of the invention. And how often does that occur, right? Unless somebody copy you, which then we can argue that they derive the invention from you. So that's a brief overview of the novelty test and the obviousness test. Thank you for joining our intellectual property education series. We hope that this journey has empowered you with the knowledge to navigate the world of patents, trademarks, trade secrets, and copyrights. Stay inspired, protect your innovations, and continue to explore the boundless possibilities of your inventive mind through the intellectual property system. Subscribe for more insights, and until next time, innovate boldly.